All persons having business before the Honorable Associate Judges now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save the United States and this honorable court. This honorable court is now in session. Please come to order.
Good afternoon, everybody, and welcome to the District of Columbia Court of Appeals. Our oral argument this afternoon is being live streamed over YouTube. We have one case that we're having argument in as a special sitting. That's in re MENSAH 20 BG 560. It's kind of an unusual case in that both sides are, I think, taking the same position. And so I tend to think that there won't be any need for rebuttal, although if people have some different view, please let me know. I'm also not entirely sure if the parties have agreed or have a preference about which of them will go first. If the parties have a preference or have agreed, I'm happy to accommodate that. Has that been a topic of discussion?
Judge McLeese, we have agreed that the disciplinary counsel will go first.
That's fine with us. And Mr. Fox, you may proceed when ready.
Thank you. May it please the court, I want to address three issues with the court. The first is I want to make the argument that there is no inconsistency between the recommendation of the board of a 3-year suspension with a fitness requirement for reckless misappropriation and the Adams case. The second thing I want to address is why that particular sanction is consistent with the goals of the disciplinary system in imposing sanction. And then the third thing I want to address is the Regas case, which the court asked us last week to address. Before saying any of that, let me emphasize that what we are talking about here, and only what we are talking about here, is a reckless misappropriation and a sanction of a 3-year suspension plus requirement of proof of fitness, the second most severe sanction that can be imposed. We have not asked and will not ask, at least I want to leave the door open a crack for years down the road, but for that sanction to be imposed in a case of intentional misappropriation. We are limiting ourselves here only to reckless misappropriation. And I guess the second preliminary.
Can I ask you before you move off that preliminary point, is that because you think it would be inconsistent with Adams to apply negotiated discipline to avoid disbarment in a case of intentional misrepresentation, or because you think it wouldn't otherwise be justified?
It's because I want to be conservative and take it one step at a time. But if you look at the only case in which the court has not imposed a sanction of disbarment for misappropriation, it was an intentional misappropriation case, Hewlett. Now, there are obviously extraordinary circumstances there. And so there may be cases and things that develop down the road, but I would, at this point, want to see how this plays out and how this works before I would suggest. I'm not sure saying I would ever suggest that we apply it to intentional misappropriation, because I think there is a greater degree of culpability in most of those cases. But at this point, I would want to take things one step at a time before I authorize such a negotiated discipline. So if that answers your question, let me turn to why I think this resolution is consistent with Adams. And Adams did leave the door open for a sanction less than disbarment in cases of especially strong mitigation factors. And it's our position, I mean, let me say at the outset that Adams and litigated cases are one avenue and negotiated cases are another avenue, but it's our position that there's no real inconsistency here, that it is an especially strong mitigating factor when a lawyer is willing to say that I will immediately accept a suspension of 3 years, the maximum suspension that can be imposed, and I am willing to accept the fact that I will not be able to practice again until I can meet the burden of proving my fitness to do so.
Now, do you have any sort of If that's right, that if we considered it an especially strong mitigating factor, I think another thing Adam said is, and it needs to be enough to outweigh any aggravating factors. Now, we don't have anything here like a holistic test that says, but only if it's the first time, only if there was no prior discipline, only if no client was aggrieved. Do you have anything like that to cabin the rule that you're proposing? Or is it just case by case? We'll take them one at a time and figure out what we want to, what's okay and what's not.
Well, one of the things I think the court has to wrestle here with is what sort of discretion you want to give to my office. Obviously, a negotiated discipline situation does give discretion to the Office of Disciplinary Counsel. The provisions say, for example, that if we refuse to negotiate, that's not something that anybody can review. So we have some discretion there. I want to take this on a step-by-step basis. For example, you said if there were a previous instance of, I suppose we can posit a case where a lawyer has already been found to have engaged in reckless misappropriation and comes back a second time. I would think that would be an unlikely case for us to want to negotiate. But I would like to take that step by step and would ask that you give us the discretion to do that. And this is you use the phrase cabin, this is a cabin discretion because everything that we do is subject to the review of a hearing committee. And that's quite an in-depth review, including going through all our files, and that includes work product. But I don't know every case that's going to come down the road. None of us do. And so my suggestion is to take it step by step.
I want to make sure you were using the phrase exceptionally strong mitigating circumstances. Another phrase we have used that we used in Adams and that we've used often thereafter is extraordinary circumstances. Do you see a difference between those, or are you arguing that we should be applying one of them rather than the other, or do you take them as equivalent?
I would take those as equivalent. I don't see a distinction between those. Maybe I'm missing something.
And are you arguing, it sounds as though an aspect of your argument today, at least, is that there's no inconsistency because a negotiated discipline case like this is itself extraordinary circumstances.
Yes.
And so there it's into the, and let me just ask you a hypothetical about that. So imagine that what had happened in this case is that your office had not been willing to accept 3-year suspension with fitness requirement and had thought on balance that the appropriate sanction was disbarment. And imagine that Mr. MENSAH had come in immediately as soon as the charges were brought and said, I did it, it's reckless, but I think that there are extraordinary circumstances because I'm admitting it right now. I'm doing everything that Mr. MENSAH did in this case. And so the sanction, the only thing I'm fighting with you about is the sanction that I think is appropriate is 3 years with suspension, 3 years with fitness requirement. And your office had taken the contrary view and that matter had come up to us. Do you think that everything that Mr. MENSAH would have done in that hypothetical, which is exactly what he did here, would amount to exceptional circumstances?
Well,
he would have immediately admitted, he would have made people whole, he would have brought attention to the problem on his own, he would have been acquiescing in a 3-year requirement. So is that all extraordinary circumstances, even if you don't agree, and even if it then has to get litigated, and even if there's no kind of efficiency value?
I think you catch me in an interesting situation with that hypothetical because I'm certainly not advocating here that in a litigated case, Adams should be cut back. But you are positing a case, in essence, I think, where we have not appropriately exercised our discretion to allow somebody to enter into negotiated discipline.
Well, that's not, just to be clear, that's not intended to be an aspect of my hypothetical. I don't have a view necessarily. Maybe you do. Maybe you thought what you're proposing and agreeing to in this case is the only legitimate way you could have responded, and it would have been unreasonable for you to actually seek to disbar Mr. MENSAH but I'm not assuming that. So, and maybe that's true, maybe it's not true. I don't know. But my only point is I just get a little puzzled about your saying that the things that Mr. MENSAH did are extraordinary circumstances or extremely strong mitigating circumstances. Because if that's true, as my hypothetical was intended to ask, it seems as though that would be true in a contested case if you're focused on what he did. And now maybe you could, anyway, so that's why I'm interested in your answer to what you're acknowledging is a somewhat, I don't know, tricky hypothetical. I'm not trying to be tricky. It just is a problem I'm having.
I mean, I think what I have to fall back on there is the point that I made glancingly at the outset, which is that there really are two lanes here. And while I'm trying to argue that there isn't any real inconsistency with the, if you will, the thrust of Adams, if you go down the litigation lane, you are by Adams driven to the situation where the sanctioned disbarment. If you go down the negotiated discipline lane, there may be a lesser sanction. And I think that makes sense, Judge McLeese, for a couple of reasons. First, I looked at some statistics, and what I did was I looked at all the cases that had been originated by my office in the last 10 years, and in which this court had found either reckless or intentional misappropriation. There are 19 of them. The average time between when we initiated charges, and not when you made your final determination, but between when the lawyer was suspended, because in each of these cases, once the board acted, the lawyer was always suspended on an interim basis, was 818 days. It's about 2.25 years. 3 of the cases were over 1,000 days. Only 2 were under 600 days, and one of those was 596. A lawyer who says, and if we and the lawyer agree that the lawyer will be suspended before that amount of time lapses, the lawyer is giving up his ability to practice law for probably a period of 2 years, which he would have normally been able to do until he was suspended on an interim basis in the normal case. At the same time, that lawyer is subjecting himself to the requirement that he prove fitness before he's readmitted. And that is not an easy thing to do. The vast majority of lawyers who are suspended with fitness or who are disbarred never come back. I've been doing this for a little more than 10 years, and of the cases that I have personally tried, not a single person has applied for reinstatement.
I mean, it sounds, if I'm hearing your answer, Judge McLeese's question right, part of what you're saying is extraordinary circumstances might exist in something outside of the particular respondent's behavior. Is that right? And if so, have we ever suggested anything like that?
I certainly think the answer to the second question is no. I have not suggested it. And you're right that I am suggesting it, although I do want to fall back to my position that we have 2 separate lanes here. I mean, after all, when Adams was written, there was no such thing as negotiated discipline. That came into play 2 decades later. And so we have 2 separate lanes here. All I'm trying to suggest, I'm not trying to suggest that Adams requires this result, for example. Obviously, when the court wrote Adams, nobody was thinking about negotiated discipline. I'm just suggesting that there is not the sort of discrepancy between the concepts that underlie Adams and negotiated discipline in these cases as, let's say, the dissent in the, if I'm going to pronounce this right, Agua, the other companion case.
Agua Wednesday, maybe?
Yeah,
something like that.
I apologize to the gentleman, but that the dissent would suggest. But
Can I ask you about you used this metaphor a couple times that negotiated discipline and contested cases are 2 separate lanes, and you've suggested at the time of In re Adams, like nobody could have been thinking about the possibility of negotiated discipline as a separate lane. And I guess I take your point to a degree, but I have a question about it, which is the following. Hasn't it for a long time been a generally available mitigating circumstance in bar discipline cases if the respondent reacts right away and says, self-reports, let's say, for example, or then says, you brought this problem to my attention. I agree. I'm not contesting anything. I acquiesce. I'm not, so the idea of mitigation through cooperation was alive and understood at the time of In re Adams and since, before it got formalized in the way it did in negotiated discipline rules. Do you agree with that or disagree with that?
Certainly let's take misappropriation off the table for a moment. Certainly in the standard case, that would be a factor that you would consider an aggravation, that the person accepted responsibility and did the right thing and came in and said mea culpa, that sort of thing. What I think the court has said in Adams was that doesn't matter in an intentional or a reckless misappropriation case.
Right, and my problem is, the reason I ask you that is if the same idea was around at the time of In re Adams, wasn't reflected in a rule. And what we said in re Adams was this kind of conduct is so grave that the ordinary mitigating circumstances, which we would have well understood, included cooperating, admitting what you did, and trying to make people whole, and all the things that are, many of the things that are reflected in the negotiated discipline process. They're not going to get the job done, and you're going to get disbarred unless you have extraordinary circumstances, which is something different. And the question I have then is, if, though not by, although the lane wasn't named this and it wasn't painted quite the same way, if this was a well understood lane, and we said in Adams that's not a good enough off ramp, you're going to have a better off ramp, then it seems like it arguably does cut against what we were holding in Adams and in subsequent cases to allow that, to kind of reopen that off ramp under the negotiated discipline rule.
Well, look, I will agree that this is not the result that Adams envisioned. There's no question about that. I guess I would make 2 points. Well, really 1 point. We've always had consent to disbarment. And in the situation that you posited, the option that the lawyer has always had is to consent to disbarment and start his or her 5 years running sooner. And then if they intend to do so, seek readmission sooner. So that existed at the time of Adams. So you did have that. This is different. This was enacted by the court after Adams. I can't tell you it's 100% consistent, but the court, did this, and there was nothing in the rule that the court enacted that said negotiated discipline doesn't apply to these types of cases. There was no suggestion of that whatsoever.
Well, this may get in Regas, because there was nothing in the rule that said negotiated discipline doesn't apply to crimes of moral turpitude. And in fact, we held that
well, actually, I think
nothing in the rule about whether it applies or doesn't apply to reciprocal discipline. And we said it's applicable. The issue is, in our case, is not so much is it globally applicable, but how does it interact and what does that open up in terms of additional discretion about sanctions? And what we said in Regas was really what the board did in the first instance was to impose some pretty strict requirements so that negotiated discipline wouldn't be an end run around a legal requirement. And the board imposed those for that reason, and we adopted those. And so, I get that the legal restriction comes from a different place. One is statutory, one, if it is a barrier, comes from our decisions. But there seems like there's a sort of a structural similarity, and I'm quite interested in how you view them differently.
Well, I will go to that, although I do want to return to the point about why it's consistent with the goals of the disciplinary system. But let's go to Regas, or Regas, I'm not sure how it's pronounced, but the point that you made, I think, is an important point, which is this is that it is mandated by a statute that a lawyer who commits a crime of moral turpitude be disbarred. So we're in a different atmosphere or different than we are with Adams, which is a rule that was created by this court. That's a statutory requirement. So I think that's one distinction. And it would be inconsistent with the statute for us to negotiate a lesser sanction than disbarment if there were evidence that the lawyer had committed a crime of moral turpitude. The second thing that's different, and this is a point that I was going to make when I was going to address the issue of the goals of the system, is that in the criminal conviction situation, the lawyer is already suspended. I mean, the way the process works is that this court is notified that the lawyer's been convicted of a serious crime, and the court immediately suspends the lawyer. And the reason that's important, and this does allow me to go back to the goals of the system point, is that immediate suspension, it seems to me, is very important in terms of the goals of the disciplinary system. I mean, the court has articulated, and Reback is one case, and that's en banc as well, but we've said this in many different ways and different times. Three, I think, goals for the disciplinary system and for imposing discipline. The first is, this sounds like I'm denigrating it, I don't mean to be so, but the aspirational goal, if you will, of the integrity of the profession. And in a number of cases, you quoted in Adams a case called Quimby, and you said it most recently in the Gray case. What you're talking about is the public perception. What's the public perception if lawyers who, and the term was used in Adams, is embezzlers, are permitted to practice law? And I will concede that there is a greater opprobrium to disbarment than there is to a suspension. And obviously it's 5 years instead of 3, although practically how much difference that makes, I'm not sure. But if you're talking about public perception, if that's one of the concerns here, what's the public perception?
Mr. Fox?
Yes, sir.
We are a panel. We are not the en banc court. And you say that there's a distinction between the moral turpitude and what we have here. That one is by statute and the other is by a court. That, of course, is true. But the court, in this case, was the en banc court. And what was presented to the en banc court was the question of this: what is the sanction that is imposed upon a lawyer who recklessly or intentionally misappropriates clients' funds? And a lot of the considerations that are being talked about and that have been talked about over the last 30 years, the ill-at-ease feeling that maybe a strict rule is not really appropriate. Judge Farron dissented on that ground. Judge Schwab dissented on that ground. But the court said, misappropriation of funds is a different animal, and the sanction shall be X. Now, you say there's two different routes: disciplinary, contested cases that go to the board and then to the court, and negotiated. But surely the negotiation must take into account not only what's being negotiated, but the sanction that's going to be imposed at the end of the day. If there were a statute that said the penalty for burglary is 10 years to life, the prosecution has a lot of leeway in negotiating the sanction, but it does not have any leeway to say the sanction will be 5 years. And for the life of me, I mean, I can understand the concerns that are being expressed. I can understand what you call the practicalities of the desirability of there being able to be a swift resolution. But it's hard to get through my head in any event to say that somebody can misappropriate funds, can come to you and say, yeah, I should have done it. Let's negotiate. And you can say, yes, the Court of Appeals says the sanction shall be 5 years. But I will agree and will argue to the board that it should only be 3 years. What am I missing? What is the hole in that kind of approach to what's going on? I mean, you could petition, you could ask for the rule on negotiated discipline to be changed. It's a rule which the Board of Judges has laid down. It can be changed. You could seek en banc review of the Adams case. There are many different mechanisms, but it strikes me that this particular one that is being proposed, namely, we can ignore the sanctions that are imposed upon people in contested cases when we do negotiated cases. And I think our court, in dealing with negotiated cases, has always looked at the acceptable range and has usually said, this falls on the bottom side of the range, but it's okay. It's within sanctions that we've dealt with. But there is no range, says Adams. We have no range in this sort of case of misappropriation of funds, except in exceptional cases.
Well,
Where am I? What? Am I crazy? Is there something I'm missing totally?
Judge Stedman, what I would say is, I guess, at 2 points. The first, as you yourself just acknowledged, the Adams does leave the door open for exceptional situations. And my argument is that when a lawyer is willing to immediately accept a 3-year suspension and subject himself, and I think in fairness, it's not just a 3-year plus a 5-year period, it's 3 years plus fitness, because that's a very significant difference, as the court has acknowledged in cases like Cater. But I would argue that's an extraordinary acceptance of responsibility. But the second thing I would argue is that the court en banc adopted Adams, yes, but it was also the court that created the negotiated discipline regime 2 decades later, and no indication in there that it was limited to any particular type of case. And the criminal cases involving moral turpitude are separate in that they were not, the requirement of disbarment was not created by the court, whereas Adams was created by the court, negotiated discipline was created by the court. The requirement of disbarment in the criminal cases involving moral turpitude is a statutory one. And so I would, I think the court has the authority, a division of the court has the authority to do what we have asked it to do. And the point that I was making before about the consistency of the goals of the disciplinary system and the notion of the integrity of the profession and the public perception, what is the public perception going to be if we say that, yes, here's a lawyer who has engaged in misconduct and is willing to be immediately suspended, But because we want to go through this process and have him disbarred, he's going to be allowed to practice for 2 more years, even though he has engaged in reckless misconduct, endangering client funds. I think removing that lawyer more quickly serves the interest of the disciplinary system. It certainly serves the second goal of the system, which is protect the public in the courts, to get that person to stop practice. You know, we don't have numbers yet, but I would say 2 years before the system causes them to do so.
Hey, can I ask about just one question?
Those
about
are good
practical-
arguments, but you're making them, it seems to me, what you're really saying is, by implication, the board which promulgated the disciplinary system, which it did, I probably unanimously, by implication, modified the Adams rule. That's pushing it really pretty far. But the same board that created the disciplinary system, if you wanted to, I suppose, could put in a section which would do what you want, which would say the Adams provision doesn't apply to negotiated disciplines. That's what you want. But I think that would be rather a shame. I think it's kind of, well, I shouldn't say, I would have no say. But that's quite different from saying the Adams rule at present does not represent the sanction that is imposed for the offense to which this person has, so to speak, pled guilty.
I think I'm asking a little bit, I mean, I've sort of conceded that there is not a perfect harmony between the negotiated discipline concept and Adams. But I think I'm asking for a more narrow ruling than the way you've stated it. I think what I'm asking for is the court to say that in a case of reckless misappropriation, where there is negotiated sanction of the second most severe sanction that could be imposed, and the lawyer is willing to accept that, and it's consistent with the goals of the disciplinary system for that sanction to be imposed more immediately, that falls within the special circumstances or the extraordinary circumstances or the extraordinary mitigation, whatever the phrase was, that Adams used to say that there can be a case in which there is misappropriation where a sanction of less than disbarment is imposed. And of course, the court has done that once in the Hewitt case. And I would say, or argue that this is an exception that the court ought to also adopt in this limited number of cases like it did in Hewitt.
Counsel, I know we've kept you over your time. Just one more question for me, and it's a practical one. If we disagree with you and think this is not appropriate for reckless misappropriation, I guess I have a question about what that would mean in effect. And let me put it this way. What's to stop disciplinary counsel from saying, look, negligence, recklessness, it's often in the eye of the beholder. It's a fuzzy line between the two. We're Mr. MENSAH, we think this is reckless, but we know it's negligent. And so if you will agree to be disciplined on counts of negligent misappropriation, then we'll give you, recommend a 3-year disbarment or suspension. The exact same thing you've done here, other than you call it negligent instead of reckless. Is that an avenue that you think is still open to you? B, is that much worse than what you're asking us to do here?
Well, I would hope that there is some assumption of integrity in this office.
Well, that's why I prefaced with negligence and recklessness is often
Right.
in the eye of the beholder. It's quite a fuzzy line. And, you've seen in our cases that there's a lot of disagreement about what meets those two standards.
And there's no question that if we had litigated this case, or if we are compelled to litigate this case, that's probably where Mr. Flint, who is going to argue next, is going to be arguing in front of the hearing committee that is negligent instead of. But I guess the second point I would make is that while I am asking
before you finish your first point, I know you're well over time, so I apologize for belaboring Judge Steele's question. But just you responded to his question in part by raising an issue of integrity. And I mean, in the criminal setting, it's very familiar that a defendant who is, the prosecutor thinks is factually guilty of first-degree premeditated murder might well be permitted to plead to something less than that. And that no one thinks that undermines, that reflects lack of integrity. I don't know, no one does, but the system doesn't view that as reflecting a lack of integrity by the prosecution. It's just an understood authority that the prosecutor has to say, look, our position is X and we think we could prove X, but the defendant is willing to plead to half of X and we're going to accept that. And so I think, I don't know that integrity, as long as the disciplinary counsel was clear about what it was doing, I'm not sure integrity would be a barrier. If disciplinary counsel said, here's the situation. Our position is that this is reckless misappropriation. But our view is that a reasonable sanction of 3 years suspension plus fitness is the appropriate substantive outcome. And Mr. MENSAH is willing to admit to negligent misappropriation and acquiesce in that sentence. So, board, we recommend to you that you accept that, even though it reflects there's no meeting of the minds of the parties about exactly what the nature of the misconduct was. There is a meeting of the mind about at least it was X and the appropriate sanction is Y. And we recommend that, on balance, the system will work better and we'll have much more time to do everything else we need to do more quickly if you accept that. And so I don't think that it's an integrity issue necessarily. And so the question remains to me, that is really Judge Steele's question, which is that something you think the rules permit?
Well, I was actually going exactly there. And when I use the phrase integrity, I did not mean to sound like I was insulted by the question, but there is a distinction between the criminal system and the disciplinary system. And that is that the discretion of my office is much more restrained than that of a criminal prosecutor. For example, before I bring a specification of charges, a contact member has to approve, and that's can be a rigorous investigation. And they go through we take our files, everything, work product, and ship it. Well, in the days when we used to ship things physically across the street to the board office, and somebody goes through them to make sure that we are not doing what I think you're suggesting might be done in the future. I mean, it's been the sort of ethos of the system that you don't do that. And I mean,
that's where I get a little puzzled about why. I mean, I get the idea, maybe at the front end, the way the system works, you'd have to bring the highest available charge, and then the negotiated discipline would be thereafter, and you would be very candid and say, we brought this as a reckless misappropriation case, but we've worked out a deal where he'll acknowledge that it was at least negligent, and everyone will agree to the following sanction.
We have been operating under the.
And just to be clear, I'm not quite sure why, if that is contrary to the ethos of the system, I'm not sure why it seems worse than, and this is the second half of Judge Steele's question in a way, why is that worse than what it is you're seeking to do here? Why is that not contrary to the ethos of the system? If instead what you're doing is saying, don't do fact bargaining, but do sanction bargaining. So don't do, characterization of the offense can't be bargained, but sanction that otherwise would be applicable can be bargained. Why is one more problematic than the other?
It has been the assumption all along that is not permitted by the disciplinary system. Because I was going to add to the contact member situation that when we have a negotiated discipline, What we do is the same process, except instead of sending it to a contact member, we send it to the hearing committee that's going to hear the case. They go through our complete files. They have an ex parte meeting with us. One of the things that is frequently the subject of that meeting is, well, why didn't you bring this charge? Did you have evidence to support that? The whole thrust of it is to make sure that we are charging all or at least the most significant violations that we have sufficient evidence to charge. Now, I don't think there's anything wrong or unethical with the kind of situations that you posit and Judge Deal posits. That's just not been the assumption, I think, in which all the parties to the system have operated for 45 years. That's not something that we do. And if we attempted to do it, I think we would be called on it and that a hearing committee would not approve it. Now, if the court thinks that's appropriate, I mean, I have not thought my way through this all the way, but if the court thinks that's an appropriate way to go, that's something that we could think about. But I will just tell you that as somebody who has been involved in this system since the 1990s, that it has always been the assumption that we can't do that. We can't give up a serious charge, and we can't, and that we have not been able to bargain in the fashion that you've suggested.
Thank you, Mr. Fox. I'll give you a minute if you want to wrap up. Feel free to take a minute. Otherwise, we'll hear from Mr. Flint. Mr. Flint, you may proceed.
Thank you. May it please the court. I'm Justin Flynn. I represent respondent Paul T. MENSAH. And our argument here is very narrow. We believe, Mr. MENSAH, that this case is the model for what this court wants to set forth for the bar. And that is as follows. A member of the bar, immediately upon awakening of knowing that he has a problem with his trust account, admits to it, owns it, has remorse, hires a bookkeeper, makes sure everything is correct, ensures the client's paid appropriately, makes sure any kind of third-party lien holders are paid appropriately, and the system moves forward efficiently. The policy that this court would be promoting, if it rejects this kind of procedure, and to address Judge Stedman's point a few moments ago, the procedure that was adopted by this court in 2008 involved a 12.1 rule for negotiated disciplines, other than consent disbarment. At that point, the court had within its power to say no reckless misappropriation cases are allowed. They declined to do that in 2008. That was 18 years after Adams. So by implication, reckless misappropriation should be on the table for disciplinary counsel, who has agreed with Mr. MENSAH that this case is extraordinarily important to move forward within the system.
I mean, do we carve out anything from the availability of negotiated discipline? I mean, I think you would agree that, crimes of moral turpitude, we have a statute that says they're not going to be, I forget exactly what the language is, but there are some that, automatically result in disbarment, and yet we didn't bring those outside the negotiated discipline, but I think you'd agree with me. They cannot be negotiated down from mandatory disbarment, right?
So DC Code 11-2503 specifically speaks to crimes of moral turpitude, and I believe are a rare set aside, Your Honor. I believe that since Adams was well within this court's view from 1990 to 2008, when this system was set up, there was a design behind it that could have easily said all cases involving misappropriation are excluded. It just doesn't say that.
Well, no, but Bill's question is, it maybe on your view should have said, if it was going to be comprehensive about how it interacted with other provisions, it should have said, oh, by the way, this is not going to be a way in which you can avoid disbarment for crimes of moral turpitude. And it didn't say that either. And that suggests maybe that the court, when it promulgated this rule, wasn't really trying to cover the waterfront of saying how it interacts with other provisions, and that was going to be left for people to sort out if there were particular provisions that created complications. You know, we create a general system of negotiated disposition, but we don't really lay out all of its interactions with other provisions. And so I guess the question is, are you putting too much weight on silence in a provision that creates a general system, but seems to not discuss some other pretty important topics if it was going to get into the topic of interaction with other legal requirements?
Your Honor, I would never presume to be in the mind of the court. I'm just a respondent's counsel. But what I can tell you, the statutory construction principle that you can rely upon is if it's not specifically in the plain language, it was intended to be excluded. And it was not in the
So
language.
just to be, does that mean you think that it was a mistake in, well, I mean, if that's right, if you apply that principle here, one of two things happened. Either it was a mistake in re Regas to curtail the operation of section 12.1 in the context of crimes of moral turpitude, or section 12.1 itself was mistaken because and unlawful because it was apparently intended and should be construed as intended to permit negotiated discipline even in crimes involving moral turpitude. So which do you think it's one of those two things, or do you think there's a third thing it could be?
Your Honor, I believe both require statutory construction. DC Code 11-2503 is pretty clear that moral turpitude crimes are out. You're disbarred. And we have a similar rule by this court that says, by negative implication, reckless misappropriation cases are not ruled out. As a result, disparate counsel, along with Mr. Mensah, worked collaboratively here. And I wanted to.
I just want to stick on this point because I still don't think I understand your argument. I mean, the way, is anybody saying, I don't know if there's an argument that you can't negotiate reckless or intentional misappropriation, or that you can't negotiate a crime of moral turpitude. It's just that what you're negotiating for is a swift end to, a swift bringing upon of your disbarment. I mean, that can still be negotiated. You can agree. I mean, you're still under 12.1. I agree that I need to be disbarred. I'd rather get this over with quickly. So 12.1 still applies. Am I missing something?
Yes, Your Honor. The actual language of the rule is negotiated discipline other than disbarment by consent. So the language of the title of the rule specifically says that if you're going to go and get a disbarment, you might as well just do that.
Can I ask you though, but what if I negotiate, so let's say I committed reckless misappropriation, but I believe I have extraordinary circumstances of the kind recognized in Adams, either because I have cursing mitigation or because I have, some extraordinary circumstance, like I did it to help my client. I assume that I could negotiate discipline in cases of reckless misappropriation and try to get disciplinary counsel to agree and the board to approve a disposition that involves reckless or maybe even intentional misrepresentation, but doesn't lead to disbarment because there is, there are the kinds of extraordinary circumstances recognized in Adams. Do you agree with that?
So I want to answer two parts to that, Your Honor. Number one is if you're going to deal with cursing mitigation, there's a bifurcated proceeding. We could stipulate on the front end for the liability phase, and then it would switch over, and I would have to prove as a respondent's counsel the cursing mitigation. I do believe that's it.
Make sure I understand. You're saying you don't think you could negotiate, you couldn't include cursing mitigation in negotiated discipline?
It would be unnecessary. I could stipulate to the liability phase and cursing phase, and I could then try my case. And I have done this, Your Honor.
But again, the reason I'm asking these questions is because it's a thrust of one of your arguments is you have to understand Rule 12.1 to be applicable to reckless misappropriation because it doesn't exclude it, and therefore it should be interpreted as applying. And so we're trying to figure out whether it could be applicable, but wouldn't necessarily require any change to the legal rule announced in Ray Adams. And so my question, again, just to make sure, that's the context for my question, but then the question is, assume that I am hoping to get a favorable sanction at the end of the day from disciplinary counsel. and I'm charged with reckless misappropriation, and I believe I engaged in reckless misappropriation, I believe I have cursing mitigation. Disciplinary counsel, I tell disciplinary counsel, look, I'm willing to admit to reckless misappropriation, but I don't think I should be disbarred. I think I have cursing mitigation. Here's what I would prove to you. And disciplinary counsel looks at it and says, you know what, I agree with you. This is a case of reckless misappropriation with cursing mitigation, and let's not have a hearing. Let's not contest anything. Let's instead go to the board and say, look, we've negotiated the following disposition. Everybody's going to agree it was reckless misappropriation. Everybody's going to agree that it was cursing mitigation, and everybody's going to agree that it would be, I don't know, a 2-year suspension with fitness, whatever the people agreed on. That's something that could happen, and this rule would then be operating to permit negotiated discipline in a case that involved reckless misappropriation. Is that right, or am I missing something?
So it's right in part, Your Honor, and if I could just explain. So the way this process works, and I think it's educational for the court to hear how practitioners go through it. We have a range of possible sanctions when I consult with respondents, working through the system. So we stipulate on a set of facts, and then we lay out with our partner, the disciplinary counsel, if they choose to agree, and there's a range. It's not cookie cutter. And we're submitting to you that this case is exceptional. And for instance, Adams would still be on the limited hearing docket. It would be possibly on the negotiated disposition. It would be well in front of Mr. Mensah in this case, knowing that he was taking some risk if he wasn't exceptional. In this particular case, the court needs to take into consideration that the whole system has supported the exceptional nature of Mr. Mensah's conduct, that they want the bar to embrace his conduct. That is, the board on pages 6 to 8 specifically evaluated the effectiveness of having a quick resolution. I will tell you the practical nature. If this court takes the opposite approach, we will be forced to, and we will be recommending to litigate from the start, from jump zero, all cases involving this, and we will just not ever give quarter to it. We'll have cases like Harris-Lindsay that last for 20 years. I believe my colleague said it was 18 years, to be precise, when they brought the initial charge to an informal admonition at the end. If that's what the system wants, that's fine. But there are very smart attorneys on the board and Mr. Fox's office that know that this is the appropriate policy. I encourage this court to look at Mr. Mensah specifically. The mitigation and Mr. Horace concurring opinion for the board report on page 5 lists the mitigating factors. Most importantly, is he went out when he realized that there was a problem, hired a bookkeeper, took responsibility. He was a part-time private practitioner doing contract law on the side. It's important the system has this exception, that lawyers who mistakenly mishandled money for 6 months, and I mentioned the time, okay, that Mr. Hora addresses in his concurring opinion. This was a brief period of time, owned up to it, and as a result, tried to work through the system through Rule 12.1. We submit this case as appropriate to be accepted, to encourage the bar to act the right way and not to buckle down and give the four corners approach to the system. That's not why in 2008, this court, in the face of Adams, adopted Bar Rule 12.1. I want to set it aside and address Judge Stedman's point. I don't want to conflate with the board rule 17.5 that addresses this procedure, okay? So we have a Court of Appeals Rule 12.1 and the board implementing Bar Rule 17.5 AIII.
Of course, the board can't promulgate a rule that is inconsistent with court rules and the court cases.
That's exactly right. And that's why under Rule 12.1, the board was implementing the policy of ensuring that there was a justified sanction and it wasn't unduly lenient. And along the stuff of this particular process, Office of Disciplinary Counsel multiple times has given briefs to the board, to this court, explaining why this case wasn't unduly lenient. The board, majority, and concurring opinion both believe Mr. Mensah's case isn't unduly lenient because of the exceptional factors. Under Bar Rule 12,
I ask you, leaving aside his willingness to go the negotiated discipline route, do you think Mr. Mensah's conduct otherwise would qualify as exceptional circumstances within the meaning of our decision in Adams and the cases applying?
If you're applying Gray, which is the latest reckless case that I came across, Your Honor, it would be disbarment. But I think Gray is an important case to evaluate. Gray didn't do what Mr. Mensah did. Even if we litigated the entire thing, all things being fair, it doesn't matter which lane you pick. If we went through the entire procedure and litigated the whole thing, this mitigation would still be in the record. I would still have to put on my mitigation defense after bar counsel, this way counsel rests. And under that scenario, I would still submit to you that this court, that Mr. Mensah's conduct was extraordinary. That this is exactly what the system wanted to have when it established 12.1 because of the logjam that of having these kind of cases clog up the system. It's completely unnecessary to litigate this when a practitioner has done the right thing. And that's what this court wants to promote. Mr. Mensah did the right thing, and as a result, we're accepting his highest possible sanction short of disbarment. 3 years suspension and fitness under Bar Rule 11, Section 3, which was mentioned in the board majority. So in conclusion,
This would be an uninformed question, but is there some prohibition on 4 years with reinstatement? So 3 is the most you can have. I just because it isn't. I mean, there's some place where it says 3 is the highest number. I just wasn't. I was wondering how 3 came to be the cap on the length of suspension with a fitness requirement. That may be in the rules somewhere, and I just missed it.
I'm sorry, I didn't want to interrupt. So Bar Rule 11, Section 3 specifically says in A2, suspension for an appropriate fixed time not to exceed 3 years.
Thank you.
And the board rule and the board majority mentions that this is the second step down. This is as high as district counsel could throw the book at Mr. Mensah and still have a negotiated disposition. In the absence of that, using the words of my colleague in his excellent brief to the board, this would be a presumptive disbarment no matter what. Okay, so I think that Rule 12.1 specifically contemplated today Mr. Mensah's case, and we asked the court to accept the hearing committee, the report and recommendation, and the board's report. Thank you.
Well, unless my colleagues have any further questions, we've heard from both counsel, and the case is submitted.
This court is now adjourned.